Assalamualaikum and hi. My name is Izarali binti Zamri. My contact number 289720. For the question number 1, the case involved Bank Pembangunan Malaysia Berhad, Ibu Kota, the type Iron Pipe Industry Sdn Berhad, and Loh Jiak Hong. At the request of the borrower, the bank extends 2 loan facilities, which is term loan facilities of up to 75 million and credit facilities up to 55.48 million. The defendant act as guarantor for these facilities. The security document execute between the bank and the borrower for the first facilities. That's all from me. I will pass to the next presenter.
Assalamualaikum. My name is Fajan Hussein Syahwana binti Hamdan. My matric number is 287-657. So we will move on to the next part, which is question 2. The defendant in this case raised several issues in response to the plaintiff claim. Firstly, they argued that the plaintiff failed to demonstrate the principles, method of calculation, and the effective cost of fund read in the notice of demand and notice of termination issued to the borrower. The defendants argue that the plaintiff should have disclosed this detail in the notice issued to the borrower. However, the court found that there was no legal requirement for the plaintiff to disclose such details in the notice issued to the borrower. The court held that the quantification of the principal sum, interest, late payment of interest, and charges in the notice to the borrower was sufficient. Secondly, the defendants argued that the plaintiff failed to inform them about the changes to the ECOF rate, which were supposedly outside of their knowledge and consent. However, the court found that the plaintiff had informed the borrower about the changes to the ECOF rate through a notice dated 2 September 2016. The notice stated that the plaintiff best lending rate or best financing rate effective on 1 September 2016 shall be at 6.75% per annum, which is equivalent to the plaintiff ECOF rate. The court held that the defendant's argument was without merit, as the plaintiff had fulfilled its obligation to inform the borrower about the changes to the ECOF rate. The court also noted that the defendants did not dispute their liability as guarantors but raised concerns regarding the amount claimed by the plaintiff. They stated that the amount claimed was incorrect and excessive. However, the court found that the defendants had failed to dispute the calculation made by the plaintiff in its statement of account on the whole outstanding sum. Under the first facility and the second facility through any evidence other than bare rejections, the court ruled that the defendants were barred from disputing the amount claimed by the plaintiff. The court also rejected the defendants' argument that their liability should be allocated to other securities held and realized by the plaintiff. The court held that the defendants had not provided any evidence to support their argument. The court noted that the plaintiff had the right to pursue the defendants for the outstanding amount under the guarantee documents. That's all from me. Thank you.
Assalamualaikum and hi doctor, my name is Siti Nur Farahin and my matric number is 2X7314. I will present the third question in this case study. The question was whether the plaintiff has the authority to enforce the guarantee offered by the defendants due to the loan facility being in default. Yes, the answer is yes, the plaintiff has the authority. This has happened due to various reasons. First, the guarantee agreement's condition being fulfilled. The borrower was in arrears for both the first and second facilities. The plaintiff attorney sent out a demand letter to the borrower for the repayment and to the both defendants for the guarantor responsibilities. However, there was no action done by either of them, demonstrating that the plaintiff has complied with all notification requirements and other procedures specified in the guarantee agreement. The next reason is that the guarantors cannot demonstrate that false representation or other legal defense render the guarantee void. Neither of the defendants disputes the need to act as guarantors. They only disputes the amount that plaintiff has asserted. Furthermore, the defendants argue that in the notice of demand and notice of termination, plaintiff had failed to disclose to the borrower the ECOF rate, the calculation methods, or the guiding principles. The argument were invalid because plaintiff was not required by law or security documentation to include all of this in the two documents that the defendants mentioned. And because the notice of termination and notice of demand were given to the borrower rather than the defendants. Moreover, the defendants claims that the default should be spread among the other stocks that plaintiff owns and has realized was one of the reasons. This position was completely irrelevant because it was decided that the defendant's liability under the first and second facilities would be as major debtors rather than just sureties. The fourth reason is that the plaintiff has not fully read of the securities and appointed receiver and manager. According to the defendants, plaintiff is therefore prohibited from filing these claims against them. As, as a result, the receiver and manager appointed by plaintiff over the borrower remains in effect and is making efforts based on the affidavit evidence. That's all from me. I will pass to the next presenter. Thank you.
In my personal view, I believe the defendant has no legal ground to sue the plaintiff due to the plaintiff failed to inform them of the ECOF rate adjustment, which were outside their knowledge and consent. The plaintiff informed the borrower on 2 September 2016 that its basic lending or financing rate had become effective on 1 September 2016 at 6.75%, equivalent to the plaintiff ECOF rate. This complaint against the defendant's claims an ECOF rate of 6.15% per year compared to the borrower's 6.75%. In the relevant security agreements, the borrower has consented to allow the plaintiff to modify the ECOF rate. It includes the first facility in clause 5.5 of the term loan facility agreement, and the second facility is included in clause 3.5 for both term loan and revolving credit facility. I also agree that the defendants have no right to contest the term and condition agreed upon by the plaintiff and borrower in the term loan agreement and facility agreement. Both material are unknown to the defendant. The plaintiff and borrower also agree on some essential term details in both agreements. First, any changes to the first and second facilities ECOF rates will not affect the defendant's capacity. Any ECOF rate changes will legally bind the defendants, regardless of their knowledge or participation. Secondly, unless the defendants can prove a manifest error, the plaintiff on January 31, 2022, declarations are conclusive. Defendants have been unable to show any clear mistake in the declaration or dispute the state sum. Thus, the defendant's argument against the assertion is unfounded. Both assurance papers have clear terms that defendant must follow. As a conclusion, the defendants claims that the plaintiff did not inform them of ECOF rate adjustment without their consent is not grounds for a trial. That's all from me. Thank you.
Assalamualaikum. My name is Fitrun Hazrul Syawani binti Hamdan and my metric number is 287656. So I will continue to the question 5. The guarantees for Defendant 1. Defendant 1 executed a guarantee for the TL facility in favor of Bank Pembangunan Malaysia Berhad, BPMB. The guarantee established Defendant 1 liability for the guarantee sum as a principal debtor and not merely as a surety. Defendant 1 liability was not affected by any extension, renewal, alteration or variation of the TL facility agreement or any other security or guarantee provided by the borrower. The guarantee was in addition to and not in substitution of and other rights or securities that BPMB may have had under the TL facility agreement or any other guarantee or security. For the guarantees for Defendant 2, Defendant 2 executed a guarantee for the BG facility in favor of BPMB. The guarantee established Defendant 2 liability for the guarantee amounts under Clause 2 as if it were a principal debtor and not merely as a surety. Defendant 2 liability was not affected by anything that will not discharge a principal debtor. The guarantee was in addition to and not in substitution of any other rights or securities that BPMB may have had under the BG facility agreement or any other guarantee or security. For the liability as principal debtors, first, both defendants were liable as principal debtors, assuming direct liability for the guarantee amounts rather than providing a mere guarantee for the borrower's obligations. The guarantees were clear and ambiguous in establishing the defendant's liability as principal debtors. The guarantees were in addition to and not in substitution of any other rights or securities that BPMB may have had. BPMB was under no obligation to marshal in its favor and securities or fines it may have been entitled to receive.